we get to interact with families. We see their resilience. We spend time with them, and their courage is amazing. But we also get we can fight the bullshit. We can get to the truth of the story. Because that's what a good litigator is a good storyteller that has the facts right. And you want to be that most credible person in the courtroom. Who's giving you the facts? You want it to be the plaintiff lawyer. You want it to be us, not the defense lawyer.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share this conversation with John Feder. John is a titan of consumer advocacy, with almost 50 years of experience fighting for injured people and grieving families. His combination of professional excellence and personal warmth make him one of the most respected voices in consumer advocacy today. Beyond his record 8-figure cases, he's committed to service in our profession as a past president of both the Consumer Attorneys of California and the San Francisco Trial Lawyers Association. When he's not championing justice, John is an outdoor enthusiast who loves waterskiing and bicycling with his family. He's also a passionate Giants and Cal Bears fan, though nothing makes him happier than hanging out with his extended family, including 3 kids and his grandchildren. So please sit back and enjoy this wide-ranging and deeply heartfelt conversation with John. Welcome to the show, John.
Thank you, Miles. Great to be here.
It's really nice to have you. Always start in kind of the same place, which is a little bit about your background and what brought you to the law in the first place. So where did you grow up? Where did you go to school? And why are you a lawyer?
Great question. I grew up in San Francisco, out in the avenues, never saw the sun. It was always foggy. We were kind of near the Golden Gate Bridge, where the foghorns at night were our daily, nightly melody. Went to Washington High School, and there I became radicalized by a history teacher named Effie Pandel, who studied the Industrial Revolution and the Haymarket Square trial. And the civics class changed my life. And in high school, I was protesting against the Vietnam War and in Golden Gate Park. And I was reading about all these young children terribly injured while trying to manufacture things in England. And so as a high schooler, a tall, skinny kid with a big, huge head of hair, I wanted to make a difference. I went to Cal in 1971 and worked a couple of school years at Consumer Action in San Francisco, trying to help people and make a difference. And I admired the hell out of Ralph Nader. I read his book, Unsafe at Any Speed, about the Chevy Corvair. And I just thought practicing law and being a consumer advocate would be perfect for what my desire was to reform the world. I worked in Washington, D.C. for a summer, working for a congressman named Jerry Waldy, who was a lame duck guy out of Antioch. He had run for governor in 1974 and lost to Jerry Brown. But he was on the House Judiciary Committee that was debating the impeachment resolutions.
Interesting.
Hated Nixon with a passion. I hated Nixon. Waldy was very fair. But it was a beautiful thing on August 8th, 1974, when Nixon resigned. We were like dancing at Lafayette Park outside of D.C. celebrating. And little did I know that, 40, 50 years later, we'd have somebody like our current president in the White House. But I wanted to fight for the little guy and couldn't land a job with a great plaintiff firm right out of law school.
I want to back up to, because we bounced over law school. So where did you end up deciding to go for that?
I went right after Cal. I went to Hastings Law School, and I thought about postponing it because I had a job offer to work in D.C. in the Office of Policy Development, which is where I was working after my senior year during the summer. And glad I started Hastings. I met a lot of great people, had some great professors. Ironically, it was the over 65 club that they were famous for.
Did you have Prosser?
No, I didn't have Prosser. I had Larry Eldridge.
Okay.
But we used the Prosser book as our Bible.
We've touched on the over 65 club in a previous episode, but just so people don't have to guess, what is the over 65 club for
Yes,
UC?
and now that I'm over 65, it seems ironic, but these were thought to be the venerated, old, wise professors who had come out of retirement to teach law school. And so Hastings attracted a whole group of professors, typically men at that time, but there were a few women, in their 70s and 80s generally, who were willing to teach first and second year law students. And so I thought it was great. I met my wife there, my third year in law school, my wife, Sue, and that was wonderful. I only had 5 more months left of law school. And so I was so glad I met her while I was still in school. And I knew I didn't want to work for a big corporation. I did not want to do business law. And the day that I got sworn in as a lawyer, my dad took me to lunch. And right after lunch, I'm dressed in a suit and tie with my resume in hand. I just walked the streets in San Francisco after consulting the Hastings placement office, looking for jobs where I could be a trial lawyer.
Wow.
And so I had nothing lined up. That day, I went into the offices of Winningham, Roberts, and Rogie, which was House Counsel for Liberty Mutual. So this is 1978, and the guy that interviewed me was a huge Giants fan. So I think what appealed to him about me was my knowledge of Giants trivia. So that's how and why I think I got hired. I started at the princely salary of about $7 or $8 an hour. They didn't have a full-time attorney position open, but they said they would shortly. But they were offering me a jury trial 3 weeks down the road.
Wow.
So I tried a case, 8-day jury trial in front of Gerald O'Gara, who was probably, 90 at the time, and had a great time and won a defense verdict for my client. But when I interviewed, I said, I really want to be a plaintiff lawyer. I had sent a resume to Ron Rouda, ironically, never heard back from him in 1978. And so I started working as a defense lawyer, and I loved being in trial. And I just found it really fascinating and exciting. And
was Ron with Marvin Lewis then, or was he on his own?
He was with Marvin Lewis then in 1978. And I'd had like 8 or 9 trials, and a friend of his named Conrad Donner was friendly with my mom. And Ron said he was told Conrad he was looking for somebody. And then I had a case where I was deposing his client. Ron Rouda was the plaintiff lawyer. He got a fair amount of money from this other law firm, this other defendant. And I took a real hard-nosed position. I took a really good depo. I was very well prepared. John somebody versus Soule Steele. This is now in 1981. And after that case got resolved, he offered me a full-time position. I said yes, and June 1st of 1981 was my first day. I was shocked when I showed up. He was in a pink shirt and not in a suit and tie. It was very different from the insurance defense types that I had spent time hanging out with. And he was just a really brilliant lawyer, creative, tenacious, fun-loving guy. And, we practiced together for 35, 40 years. And I brought in Tim Tejan, who had been a law clerk for me at Liberty Mutual. And it was fortuitous because I feel now that doing this was what I was meant to do. And it wasn't like I was law review. It wasn't like, I had a million job offers coming out of school. I didn't know what I wanted to do, except I wanted to fight for the little guy. And Liberty Mutual gave me, I thought, great training. They had a bunch of good trial lawyers there. John Winningham was really quite a good trial lawyer. And the one thing that he said that I remember before I went to trial for the first time, he said, now, John, evaluate your performance. Think about all the things you did right and could be improved upon before the jury comes back. Because, of course, as a defense attorney, you're not going to win every case, and you might get hammered with some big verdicts. But I thought that was good advice.
Mm-hmm. I'm reflecting upon that because that is not something that I have thought of doing, and that is a perfect time to really do that reflection. It's a good piece of advice.
Because it's easy to take it personal if the result is not what you expected, not what you were hoping for, especially on the plaintiff side when we've lived and breathed what our client's been going through for all those years. and we've seen their resilience, and we know we need to win for their sake. And if you get a disappointing verdict, it's crushing.
Yeah.
But I thought Mr. Winningham, John, had good advice. And I thought it was great training because there was a lot of unevenness in the plaintiff bar back then.
When you say unevenness, what do you mean?
Lawyers that didn't seem to give a shit about their clients and weren't well prepared. And so I was meticulous about my approach even back then as a young lawyer. And I would go through every single page of my clients, of the plaintiff's medical records. And so I knew a lot more about the plaintiff than the plaintiff could ever recall. And most of the plaintiff attorneys had not been careful to prepare their client. So I remember I had one case against a gentleman who was the president of the San Francisco trial lawyers. He was kind of a tough, hard-nosed guy. And he just hadn't prepared his client for deposition. And I had all these letters she'd written her doctor about prior back pain, prior neck pain, prior leg pain, and he had no idea of it.
It's a good opportunity to go into one of the things that I think is a hallmark of kind of your approach to the practice, at least from an outsider's perspective, which is meticulous preparation. And I'd love for you to unpack a little bit for our listeners, a little bit about how you approach, whether it's a case or a deposition or mediation or trial prep. How do you approach that with that meticulousness? And is some of that learned behavior from your time on the defense?
Some of it probably is just my natural curiosity. I always ask a lot of questions. And one of the things that, as a defense lawyer, I don't know that we hired investigators. So I would do a lot of the legwork and talk to people that knew the plaintiff before and after. I remembered as a young plaintiff lawyer, I had one case where a guy that ran an antique shop froze the tip of his finger using a can of spray paint. And so I went into like a hardware store and found like 15 different models of paint cans that had a safer nozzle design. And I used that information that I had gathered just going to, I don't know, the hardware store to show this is a defective design because it allows people it comes out super cold and allows people to suffer serious injury. So I think I've always been curious. I love learning my client's story. And I think easy for me to want to dig in. I think a key to that is being able to say no to cases. You can't do a great job if you have a whole desk full of files that are begging for attention. And one of the things that Tim Tejan, I think, taught me is just say no. Send it out to somebody who's maybe a little bit younger, maybe a little bit more desperate for cases, because you can't do a wonderful job for everybody. And what I always wanted my clients to feel is that their problem is my problem, and that I get it. I used to have a size 5 pair of Indian moccasins in my office to remind me to like walk a mile in my client's shoes. Because I think lawyers are busy, and it's very tempting to cut somebody off to get the information. You're thinking of, okay, what's the liability picture? What's the insurance coverage? But I've learned people need to tell their story to somebody who's really listening and can be a human being and a bit empathetic when they hear that story, because you want your clients to feel like you've got their back.
In terms of describing some of that listening, I know in one particular case, the family was in Canada, a wrongful death case. And I know that some of that listening involved lots of travel to Canada to be with the family, to hear and understand who they were.
First of all, I have to say what a fantastic job you did working on that case with me. I know Brian and Pat, I know you got their story, you understood it, and you were right alongside with me down in Riverside 2 days before the trial when we got that case settled.
I very much enjoyed the opportunity to work on that case with you. I do feel like I came in towards the end and had the benefit of seeing all the meticulous work that you had done in terms of understanding their loss, and saw that in the mock trial and other places.
I believe you were nominated for CAOC Trial Lawyer, Consumer Lawyer of the Year along with me on that case, because it was a remarkable result. And I spent a lot of time up in Canada. They lived in Alberta. And, sitting around the kitchen table where Patricia had been kind of the leader of the family and some would say just instrumental in the building of that business. And, I use these wonderful storytellers, Rob and Keiko Feldman with Jurors Productions to film a video up there with us. And they really helped, I think, us tell the story. The defense attorney allowed me to do the deposition of the plaintiffs, his deposition in my client's home, and that was helpful. So I thought even the defense lawyer understood how terrible the loss was to this family.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. It sounds like you need to have a pretty good relationship with your opposing counsel and establish some rapport to be able to, how have you managed in your career to maintain that civility with the other side?
Well, I think it's pretty easy because, especially in the Bay Area, the legal community is fairly small. And I think you have to treat people with respect, even if they're on the other side. And so what I try to do is forge a working relationship. These aren't my best buddies, but I'll take them to lunch or go out after a deposition and grab a beer to talk with the men and women that are representing the other side. And we'll talk about personal things and I'll give them advice on maybe other cases they're handling. And they've been a good source of referrals over the years. Like during the depo, it can get pretty darn heated, but I try not to make it personal. I focus on the witness and say, from time to time, attorneys will make objections. Remember, I told you there would be some hard questions and you still have to answer truthfully, even those really hard questions. So can you agree with me, blah, blah, blah. I'm trying to make it as easy as possible for the defense attorney not to be a jerk. Rouda taught me that. Ron was very friendly to a lot of his adversaries. And a lot of, as you know, Miles, a lot of our adversaries, they're listening to their clients who are controlling the purse strings about how much money they might be able to offer. And so I want to spoon feed them information to make it easy for them to get the dough that they need to settle a case. I think a lot of times, I'll ask, what do you need? Like I'll send the mediation brief. Is there something you need that's not in the brief that you'd like in order to get enough dough to get this case resolved short of trial? And most of the time, the defense attorneys appreciate that. Pre-lit, I try to treat the adjusters whenever they call me with respect and patience. And I often don't take that cold call, whether it's a client or the adversary calling. I'll typically look at the file, make sure I know what's happened recently in terms of my client's medical care or treatment, so that when I'm returning that call, I know exactly what's been going on. Because I think, as you've done for so many years, you want the other side to think, this is the only case that this guy's working on. He's all over it. And you want your clients to know that you have their back. And you remember it's their left leg that's broken badly, not their right leg. Because a lot of times the doctors don't remember. They'll go, oh, let's see, which was it? Was it your left or right leg that I operated on? And that's the last thing you want, I think, in terms of how the other side approaches the case. You want to come across like you're on top of it.
I want to go back over that because I think that's a really important point and not one that has come up in any of the previous conversations I've had on the podcast, which is when, say, an adjuster or opposing counsel calls, you may not pick up the phone in the moment. You will let them go to voicemail, for example, review the file, and then return the call. So when you're in a position of making sure that you have gnosis, you know it all.
Right. Because I want them to get their question answered, but I also want them to know I'm on top of this case and I'm ready to deal with whatever they've got to say. But I do prepare for that call, which is one reason I think it's important to be able to say no to some cases. I think after you've been doing this for a few years, the kinds of cases that you're going to want to work on, the kind of clients you're going to want to work on. And Karen Jo Coonan, I know the jury consultant that you and I have used over the years, who recently passed due to cancer, she taught me, as part of my conversations with my client, to find out the 5 things they're most proud of. Because even the most thorny, difficult client has 5 things they're proud of. And you want to make sure you understand that. And just the fact that they feel like you know them well, I think helps give you more credibility when you might be pointing things out that they had not fully understood. So I think you have to look for the good with the clients. But if the client seems impossible, there's plenty of other hungry lawyers that can help that person, because you want to be able to have quality of life and sleep at night and be with your family when it's time for that. So I've learned that working on a shitty case will always be a shitty case. The other thing I have to say about that is that taking that extra deposition has truly paid off for my clients. I have learned lots of things that I wasn't expecting to learn, gotten great ammunition for my client's case based on taking the extra deposition.
What do you mean when you say taking that extra deposition?
Well, for example, we had a driver of it was a Lockheed Air Terminal tanker truck that fuels the aircraft. He testified at the time of the accident, he was giving a finger and looking to his left at a unit rig driver for Pan American who was towing another plane out.
Why?
He thought he'd been cut off by the unit rig driver.
Okay.
So he wasn't looking when he ran over and ground into pulverized my client, who was a 56-year-old aircraft mechanic for Pan Am. This was in 1981. And there was a witness, honest as the day is long, that said, I saw your client, this is in depo, jump up on the tanker truck and hold on to it as if he was going for a ride. And then he fell off and got run over.
That's not a good fact.
It's a terrible fact. She was completely dead wrong. My guy was straight as an arrow and never would have done that. And he was trying to save his life when he grabbed onto the tanker right before going through these wheels that were like 6 feet tall, and there were 2 sets right on the right side. So she was just wrong. And I know you've read the books that I have about eyewitness memories. They can be as honest as possible, but not right. They glimpsed at something and made up a whole story.
Yeah.
So, taking the depositions of everybody else uncovered a lot more facts, including, deposing his coworkers. He was the last guy that would have hitched a ride on a huge truck. And first of all, he didn't have to go anywhere. There was no reason he'd do that. But I think one of the great things about what you and I do is we get to interact with families. We see their resilience. We spend time with them, and their courage is amazing. But we also get we can fight the bullshit. We can get to the truth of the story. Because that's what a good litigator is a good storyteller that has the facts right. And you want to be that most credible person in the courtroom. Who's giving you the facts? You want it to be the plaintiff lawyer. You want it to be us, not the defense lawyer.
Yeah.
That's why it's so important to listen. How does the juror pronounce their name? Don't write it on your sheet based on how they spell it. That doesn't matter. You need to be able to pronounce it and remember it. I had one trial where the defense attorney was talking to a woman, and she just mentioned that her husband had died recently of cancer. And he wasn't a human being. He didn't say, "Oh, I'm so sorry." He didn't take a pause. He said, "Oh, and what did he do for a living?" I mean, it was just like he had not heard anything important about that conversation. So I think being a good listener is part of being well prepared, because, you need to distill the facts that are out there, but you have to be listening at all times, both during the deposition, during trial, and in every context where you're, getting information.
Well, and I think that reinforces, you mentioned that you are curious. You're interested in things. And one of the challenges I think with lawyers is, if you have an outline, you stick to your outline. You don't hear the my husband died of cancer. You right. It's next question.
Yeah. Yeah. What about juror number 8? Yeah. Yeah. So I mean, that's something that I think You and I have gone to a million lectures on what works and what doesn't work in voir dire, but I think that's one of the very toughest parts of the trial because you haven't built up credibility yet. They don't know you at all. They don't know your client. I think Nick Rowley talks about, brutal honesty, getting them to say how they truly feel and embracing the bad answer. Oh, I think all plaintiff lawyers are ambulance chasers and scum. And I think any plaintiff that's asking for money for loss of consortium, I think that's evil, for better and for worse, is what the marriage vows were. I think the more you encourage them and you say, thank you so much, even though it's like in the old days, it would feel like they were stabbing you in the heart and you would avoid the controversy. But now I think you definitely need to find out what they're thinking, even if it's not helpful, because then you can make your cause challenger your peremptory.
Yeah. Thank you for listening, and please join us next week as we continue this conversation. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.